Good evening, everybody. You have joined the South Florida Hospital News legal series brought to you by Mirza Healthcare Law and the Broward County Medical Association. For those of you tuning in for the first time, the third Tuesday of every month, we have a live show, I call it, webinar, on a current legal issue facing the healthcare industry. Our experts, which they'll introduce themselves in a second, will get started with tonight's topic, and I appreciate you coming in and joining us tonight. Ben?
Hi, guys. Yeah, my name is Ben Mirza. By the way, I cannot figure out how to see you guys on this thing.
What?
Yeah, I can't see your pictures.
Maybe you can't see our pictures.
Yeah, I'm only seeing my slideshow. It changed just to my
Yeah, I don't see the slideshow there, but
Yeah, I don't see the slideshow.
You have to share the slideshow. Make sure you share.
Let me do end. Okay. Screen share, share two.
there we
Is that
go.
better?
Right.
Yes,
And your
yes.
picture should be on the side now.
Now I see it. Yep, it's on the side. Okay, perfect. And
Like I
ready
said, he's a
for-
good attorney. Tech, IT stuff, not great. So
Yes.
Tech support, please come in.
that's right.
Yeah, okay, so here we go. All right, so my name is Ben Mirza. Thank you, everybody, for joining us. Today, we're going to be talking about protecting your rights, ins and outs of hospital medical staff bylaws and the Joint Commission. The reason why we chose this topic is because, hospital medical staff bylaws are highly technical. People inside and outside on both sides of the fence don't always understand exactly what to do. And there are very few people, even inside a healthcare system, that actually understand how healthcare bylaws work and what they need to do under certain circumstances. So this is a very high critical area of education. That's important for whether you're a physician with privileges or whether you're on the inside of the healthcare system. So with that said, let me introduce ourselves before we go forward. My name is Ben Mirza. I actually have several degrees. One is in, obviously, law. Another one is in accounting. I am formerly a CPA. I also have a master's of tax law, and I also have a master's of public health from Yale. I have been a practicing attorney for over 20 years, closing in on 21 next month in April. And I have worked for large size firms, small size firms, large size hospital systems, and small physician groups. So anything and everything in between. I have been, while being on the inside, I've actually helped the hospital administrators review the physicians that had privileges. And there were times that they had to get rid of certain physicians, and there were times that they needed to bring in certain physicians. So I've helped hospital systems think through that process, as well as others on the outside when we went off on our own practice on the outside. But with that said, the person I'm really excited to talk about tonight is Ed Meyer, and Ed is actually the guru of healthcare law. There's probably not a whole lot of Eds in this country, period. But there's just a few, and I happen to be fortunate enough that Ed is our of counsel to our firm. So Ed.
Well, thank you. Yeah. Okay. Yeah. My name is Ed Meyer. I am of counsel to Mirza Healthcare Law Partners. I'm a licensed attorney in California, and I have over 30 years of experience in healthcare law. And I was thinking about this earlier today. I've hit healthcare from representation from different angles, being representing large hospital systems to individual hospitals, to individual physicians, to national medical groups, and even health plans. In the area of medical staff bylaws, years ago when I was licensed in North Carolina, I was licensed for a while there. I actually drafted the model medical staff bylaws and have helped hospital MECs suggest to hospitals their updates to their bylaws, as well as representing physicians who have to work their way through their medical staff bylaw obligations and rights. But let me also introduce Komal, our associate, Komal Mirza.
Evening, my name is Mirza. I'm an associate with Mirza Healthcare Law Partners, and my primary practice area is in assisting physicians, physicianpreneurs, healthcare providers who are entrepreneurial minded, and assisting them establish their business entities or get their private practices up and running. On that note, today's presentation should be particularly interesting for those of you who are in the hospital system sector. And we will be walking you through the medical staff bylaws, helping you navigate them and the importance of them, as well as the complexities of joint commissions. This presentation, please keep in mind, is intended for educational and informational purposes only. We're not going to be providing any form of legal advice. So if you have a specific question, please feel free to contact us at any time. Our contact information will be provided at the end of the presentation. Also, as Charles mentioned earlier, this presentation is being recorded and will be used as a public online resource in the future. So please do keep that in mind.
Okay, so starting off today, our roadmap is really going to be this. We're gonna first start off with a case, and we're going to set out the facts of the case. And then we're going to go into what governing documents are when it comes to hospital systems. We're going to go through the credentialing and privileging process. We're going to go through the peer review and the professional review activities that take place inside a hospital. Then we're going to go through actually disciplinary actions and how disciplinary actions are conducted under peer reviews. And then last but not least, then we're going to go into what's called appeals rights in circuit court, federal and circuit courts, where you can actually take the disputes eventually. So we have a lot of ground to cover. So we are going to be talking a little fast. If you have any questions, please do ask them as we go along, because it'll help us just tighten down that particular point in case if we happen to. So let's start off with market forces. The market forces in the hospital industry are this. Number one, hospitals are essentially a community resource, which is why you need a CON, right? The certificate of need is a CON, and a CON is needed because a hospital is a community resource. So the state generally, in a lot of states, including Florida, allows for a hospital to be established. So with that said, each hospital has a certain amount of influence over a geography, right? And when that geography and its people start to rely on that hospital, it has a certain right, it has a certain obligation back to the community. So the things that will arise inside hospitals is things like liability lawsuits if their peer review process is not done right. So like negligent credentialing can be a problem. If their hospital staff is not set up properly, meaning the in-house staff versus the outside staff, there's also a shifting of payment structures that happen. Who's going to bill for the facility, who's going to bill for the actual medical services provided. There is money at play here. So despite what anybody says, hospitals are, for the most part, a ways and means of not just delivering healthcare, but for certain businesses that are involved, it's where they count on for their payments. So there is often a turf war that takes place inside hospitals. Ed, would you add anything else to that?
Yeah, what I was going to add is that, you have this current situation, I think, of physicians effectively being overwhelmed by the amount of obligations they have that are outside actually of practicing medicine, all the administrative obligations, also the rise of lawsuits and whatnot. And so it's just so important for the physicians, amongst all the things they need to understand, is to really understand the medical staff bylaws and their rights and their obligations under those bylaws. And because there are several things in these bylaws that protect physicians. And if you really know them, you could actually, keep a physician, keep him or herself protected.
So quickly on that note, Ed, and Ben, just to kind of create a hypothetical case analysis here for so that everyone can have a better understanding of the implications that we're talking about, or essentially the importance of these medical staff bylaws. Say you have a physician, Dr. Jane Smith, at a hospital, and she's seen a patient. She briefly entered notes and decided 7 days later that she was going to go back and make edits to those notes. What is the perspective of the physician in that regard in comparison to the hospital, and what implications or things that need to be kept in mind, and how do the staff medical staff bylaws come into play?
So I'm gonna just talk from a hospital perspective.
Mm-hmm.
So from the hospital perspective, they're looking at a physician changing notes afterwards, after the care, after he actually had written notes initially. So they're kind of questioning, well, wait a second, why are you, again, the hospitals are oftentimes non-physicians. So they're looking at their rules, and they're kind of questioning, why is a physician changing things afterwards when the notes given more contemporaneous to the care would likely be something that they would believe would be something the physician would be much more cognizant of what actually was done. Also, the hospital is billing based upon the what the physician had performed, the services performed at the hospital. So they don't want to be changing what they've been billing out. And also the hospitals are very, very keen and aware of potential for compliance issues. And when there is a change in the bylaws, potentially, change in the notes for the care of in the medical record, they're always concerned. They could be concerned about changes that were done, that perhaps there's upcoding or something like that. So they're just very wary of those activities. So they can question it.
So even though the hospital thinks that the rules are simple and it's easy enough to do that, from a physician's perspective, it's a little bit different. The physicians are basically thinking, hey, look, I've got a high volume of patients I got to see. I am the revenue producing machine, or one of the revenue producing engines of the hospital. Give me a little bit of leeway, allow me the ability to go in and modify notes, change notes, amend notes, append notes. And all I'm doing is, as a physician, is increasing the accuracy of what is being recorded. And that's only towards the interest of the patient, right? The patient care. So if you increase the accuracy and the completeness of the notes, all you're doing is providing for your patients better. So from a physician's perspective, it seems almost kind of harmless. From a hospital's perspective, they're like, hey, why are you changing up notes when we've already built something out? And you can see the regulatory problems that arise from that, especially if there's Medicare that's involved, right? So today we're going to walk you through here, down here, you see like part 1 and part 2. There's actually dispute part 1, and which happens inside the hospital. And then we're going to walk you through dispute part 2, which is going to be a very small part of this. We're going to spend most of our time in dispute part 1, with the processes set up inside a hospital system. So let's get started. Hospital staff bylaws are really about how clinical privileges to practice are obtained, and the requirements for continued membership, right? So the medical staff bylaws not only allow people to get in, but they also help ensure the quality of care that's being practiced inside the institution. Now, the medical staff bylaws didn't just appear out of nowhere, or one day somebody woke up and talked about it. It happens to be the law of the land, in a sense that there's federal and state statutes regulating the stuff, and there's administrative codes. So when it comes to medical staff bylaws, there is medical staff bylaws will govern the actual medical staff itself, meaning the physicians, as well as their allied health professionals, so which could be the nurses, the practitioners underneath them, and the therapists. So when you
keep in mind, though, you just keep in mind with the medical staff bylaws is you have a hospital's corporation, it's licensed, and now it allows or has people who are not professionals, who I should say physicians, allied health professionals, who are not employed by the hospital coming into the hospital and performing care. So the medical staff bylaws are sort of the structure under which that piece within the hospital, but for non-employees coming in as professionals performing services they're structured, how you let them in, with their rights, etc. But it's a subsidiary of what's going on within the hospital from a legal structure.
So with medical staff bylaws, there's usually also rules and regs that may pertain to a particular department. So like, radiology may operate differently than pediatrics and so forth, and surgery versus, GI, right? So you have all these departments, they set their own rules and regulations on the inside. And when you look at this slide, the first two parts of it are really pertaining to the medical staff. And the way the medical staff rules and bylaws are done is they are done on a collaborative effort. So meaning that the medical staff and the hospital board has to approve it. So it has to technically be accurate, administratively technically be agreed to by the medical staff, as well as by the administrators of the hospital. But when you look at these bottom two areas of rules and stuff, it typically referred to as the hospital bylaws or the hospital policies and procedures. They are unilaterally set by the hospital, and that's what everybody has to follow, but they cannot contradict the other. Okay, so the way to look at this is that each hospital really has, number one, note this, there's two different bylaws going on here, right? There's a hospital bylaws and there's a medical staff bylaws, two very different things. There's rules and regulations under medical staff, but then there's policies and procedures under the hospital. And, each one is a little different. And so this red line in the middle really does matter as to how they're utilized and who has to actually abide by them. Anything else you'd add to that, Ed?
No, it's just it's important to understand there's two separate things. It's really two separate things.
Yeah, there's a separation. So as we were talking about medical staff bylaws, I mean, the way they actually come about is because under the Code of Federal Regulations, there's a minimum requirement for staff bylaws. In order for you to be a provider under Medicare as a part of conditions of participation, and you can see the statutes that are in here, it says you have to have a governing body. And it says that you have to have rules related to medical staff bylaws, and these are the citations to them. Now, those same rules allow for certain agencies or certain even third party, although the Joint Commission is not a part of the government, they assign the right or the ability to monitor and evaluate how the hospitals are doing to these other entities. Right? So the Joint Commission is one of those, and the Joint Commission also requires hospitals to have bylaws in order for you to be a participating physician or an entity with CMS. So that's where the Joint Commission comes in, and it's really important to understand that, because now you have a whole series of like a regulatory scheme behind what a hospital has to do. So it's not just unilaterally making up its mind and what it needs to do, but there's statutes and there's agencies behind this stuff. Anything else, Ed?
Yeah, no. You look at the hospital. You're going to talk in a minute about, I think, the state law. So as you'll see, medical staff bylaws. You have federal law and you have state law. Medical staff bylaws are, they're a combination of several regulations and laws and accreditation body obligations that all go into what must be in there. So when someone wants to look to change them, you have to really look and work through each of those pieces to make sure it's compliant with everything.
Also, to keep in mind, there are other governing agencies like the HCQIA, which is the Healthcare Quality Improvement Act. There's other statutes as well that apply to it. Under the HCQIA, what it does is it allows immunity for peer review process participants from adverse claims. Basically, that means that if a physician happens to be on a peer review committee, that they are immune from adverse claims. However, the immunity does not apply if it has to do with unfair employment practices, right? Either under the state or the federal guidelines. And there's a US Supreme Court case specifically on that point, that yes, all of the peer review committee and the process activities are immune from outside attack, unless if it's got civil rights issues involved in it.
Yes, again, so long as the requirements of the HCQIA are met in the structure of the bylaws and the peer review and the appeal rights, the fair hearing rights are met, then those sections of immunities apply. And again, the purpose, of course, is to ensure that physicians can review other physicians without the concern, or minimizing the concern that those discussions will end up in a court filing for professional liability.
Yeah, and then as we continue this presentation, you're going to hear NPDB. So that stands for National Provider Data Bank. National Practitioner Data Bank. And what that essentially means is if there's an adverse decision, whether it's a malpractice lawsuit or some sort of a settlement or some sort of an adverse decision made through the peer review process, it's all reportable to the NPDB. So you're going to hear us talking about it. And I just want you to keep an eye on that, because that's a big ding against a physician's license. And it's hugely important to understand that. So as far as Florida laws go, the medical staff bylaws are a contractual agreement. So the Florida law recognizes that it's a contractual agreement between the medical staff and the hospital system itself. They also say that medical staff bylaws cannot be adopted unilaterally. So by either party, it has to be a joint decision-making process. So the medical staff is tasked with ensuring that they maintain the quality of care, and they're also required to follow a due process, so that nobody on the medical staff, who's either granted privileges or denied privileges, is done so without due process. So the due process is a really huge and important thing when it comes to medical staff privileging. And mind you, most states have very similar sort of laws in place. What's true in Florida, may very well apply in other places. So this slide is primarily just to orient you as to the different types of staff that get privileges. You have the active staff, obviously, inside a hospital that gets privileges. You have the provisional staff, which are the people trying to qualify to become the active staff. Then you also have like the consulting staff that may be from outside. You may have the honorary staff, and the honorary staff are usually like the retirees, right? So the retirees have like privileges to maybe sit in on meetings, but they're really not doing like clinical stuff inside the hospital. Then you have like disaster-related privileges and maybe even like telemedicine privileges nowadays. So these are the different kinds of privileges allowed. And each different department may have different privilege levels that they allow for. So the MEC is the medical staff governing committee to which subordinate committees report to. So the MEC will have within it subcommittees, and there could be multiple different types of subcommittees. And here are some examples, right? So there's like a qualification committee, a bylaws committee, a peer review committee, a health and wellness committee. These committees will ultimately report to the MEC, and then the MEC will ultimately report to the Board of Governors. Now, do note on here that the president of the MEC must be a physician, and the other officers of the MEC, those positions must be enumerated in the actual bylaw. So if there's like a chair, a vice chair, and so forth, and all the other positions, they've got to be enumerated in the bylaws.
Yeah, and also another committee that sometimes you see is physician behavior committee, especially if it's large and you have issues. And Ben and I were talking is it's physician discipline or physician behavior, and I always like to say it's behavior because you want to encourage good behavior rather than it being immediately a confrontational type of committee with the physician. But there are, obviously there are behavior issues that come up. There's because oftentimes for whatever personality conflicts a person might have, but also because of the stresses the physicians are under in dealing with the care. So the behavior committee is also a very important one to have.
Yeah, so before anyone can become a part of the medical staff and get privileges, you have to go through essentially a two-part process. One is credentialing and the other one is privileging. So the credentialing part of the process is really essentially looking at the resume and verifying all of the information on the resume are true and accurate, and that the person does have the qualifications to practice in the area that they want to practice in. And that would also include checking on references and so forth, right? So, and looking at their background checks and things like that. Privileging is then the identification of the services and treatments that the person would be able to perform inside a healthcare, inside a hospital system. So the privileging is qualifying for the ability to do those procedures, do that sort of medical treatment. And, and it all has to be approved by the MEC. Anything else?
And then then it goes up to the governing board to confirm the physicians. Yeah.
So here's the process. Here's the 5-step process for credentialing and privileging. First, what you do is as an outside physician or as an inside administrator, you're going to go and collect the credentialing app. And the credentialing app has got a ton of questions on it, and they all have to get filled out. And then there's usually like an authorization form attached to it that authorizes the hospital to go and look into the background of the individual. It releases the hospital from liability, and it also importantly acknowledges that the physician has read the medical staff bylaws.
Yeah,
and that they agree to abide by.
And it releases for those who are being responding to inquiries on the credentialing from liability too. And it's just really important to note that all those questions on that questionnaire need to be filled out honestly and without hiding something. So there are times when, let's say, for example, during a course of a long career, the physician might have been suspended for some reason. So if the question is, have you ever been suspended? The answer is yes. And then, write an explanation for it that the hospital would understand. If you had been disciplined, you explain the discipline, what happened, but you have to be honest, because what you don't want is to come back to you during the process down the line where they find out that some information you provided was incorrect. So,
yeah. So then once that's all, and that's really important, by the way, what Ed was just talking about in terms of being truthful. Sometimes physicians are suspended for 3 days, and sometimes they're suspended for 30+ days. And 3 days is also important to actually disclose as to what happened. So if the question is there, you answer it truthfully, but then you got to make sure that you're framing it properly, and that's where we can help you. Then what happens is once that application is collected, it goes through a verification process. So the person is checked against their licensing, education, training, and the NPDB, the National Practitioner Data Bank, and then the references are checked. So that's the verification part. But step 3, where the department chair then reviews the file, looks at it to see if it can be presented to the MEC or not. This is a really important juncture right here. This step 3 right here, it basically means that the application is sufficient to either move forward or not. So do keep in mind, sometimes if a chair thinks that this application is going to get denied by the medical staff committee, by the MEC, what they'll do is they'll say that the application is incomplete. And that doesn't necessarily mean that the chair is against the person applying. It just means that they may, in fact, be looking out for them and letting you know that, hey, the timing isn't right, don't submit now. Because what happens at step 4 is hugely critical. If the MEC decides not to accept the individual in, and there's an actual adverse decision made, then that adverse decision is going to get boiled up to step 5 to the Board of Governors, get ratified, and then get reported to the NPDB. How crazy is that, right? So when it goes up to like step 4 and step 5, and if it gets denied there, wow, like it's got actual ramification, it's got teeth, it's got things in it that are going to impact the physician. So
And keep in mind that if it is denied,
Mhm.
you should be looking at the bylaws with regard to any appeal rights, because of what Ben is going to say right now on the reporting.
Which is what?
When we get reported, he gets reported the National Protector Data Bank, right?
Yeah, the NPDB will pick it up.
Yeah.
So if you go past step 3 and into step 4, now you're into this other area of where, you know, you've got a ding against your license. So whatever this department chair does, hopefully they're reserved, they're wise, they're prudent, they're not, you know, prejudiced, they're not, you know, they're like a really decent sort of a seasoned person that'll make sure that whatever they move along to the MEC will get accepted. So, and if you do get denied, or if a person does get denied at step 3, don't always look at it as a negative. I mean, there is a silver lining around that cloud. So what happens during credentialing? So in credentialing, they're going to be looking at the character, competence, training, experience. Now, the credentialing also happens every 2 years. So every 24 months, the credentialing process has to go through. Perhaps they won't look at your degrees all over again and things like that, but they will look at the, you know, background searches all over again every 2 years, if they're not doing it more often than that.
And if you're an active staff member, requirements will require a certain minimum number of procedures on to be performed. And I don't know, usually it's like, I'm not really sure how many, but I think it's like 12 last time I saw something. But again, it's those procedures because they want to make sure that you're still clinically competent, the physician is still clinically competent, and then those will be reviewed.
So keep in mind, a hospital can only grant privileges that it itself has. So like, for example, if a hospital does not do transplants, it can't give a transplant surgeon the right to transplant because it itself does not have the privileges, right? So
it has to be on the license. It has to be on the license, yes.
Yeah. And then under times of disaster, the medical staff bylaws have a different set of guidelines that they'll follow. So like, for example, when COVID-19 kicked in, come March, April of 2020, you're right, 2020, you know, a whole other set of guidelines were kicking in because people were short staffed and they were trying to in a scurry. So if your medical staff bylaws do not have disaster privileging guidelines in place, please make sure that you do update those things in your bylaws.
And also keep in mind, it's real important too, is if you're currently working under disaster privileging, because of certain waivers that are out there to the conditions of participation or certain other waivers that are out there to licensing rules, once those waivers are over, the hospital will need to kind of go back and make sure that they're not otherwise violating rules that were waived but are no longer waived after the state of disaster is no longer declared.
Good point. So then credentialing also again has a whole due process to it. The HCQIA grants immunity to the committees that are involved. Here's the actual Florida statutes that are involved here that allow for immunity to the committee, as long as it's found that the actions taken by the committee were in furtherance of healthcare quality, that the committee made a reasonable effort to obtain the facts of the matter, that after notice and hearing that was fair to the physician under the circumstances, that there was an opportunity given to the physician to actually refute the things that were being found, and then a final action was warranted under those circumstances, they will have immunity. No, but do keep in mind that there is no immunity if the hospital failed to exercise due diligence in credentialing or monitoring. So they also lose immunity for that. If the applicant is denied, it is probably a reportable event. So keep that in mind. Now, let's talk a little bit about the peer review process, right? So what's the purpose of the peer review process? The purpose of the peer review process is really to improve quality, right? It's all about quality. So net, what the peer review process, what it means is that physicians are, that a physician is getting reviewed by other physicians, right? So that's peer review. The concern or the fallouts are that if something adverse is found, it can have a really negative effect. So there are several things that an MEC can do before they formally go after a particular physician. And here's 7 of them. So here are some things that can be done. One is collegial intervention. So really just going over and talking to the individual and seeing what they're, just talking to them about what's going on. Maybe there's a complete misunderstanding on the part of the observer, or maybe not. Education is another one. If you keep seeing that particular physician and maybe a few others keep making the same mistakes again and again, maybe it's time to like dust off those presentations and say, hey, here's like an educational slideshow for 10, 15, 20 minutes and walk them through that process. So like, for example, in the case of the notes that we started off with, right? The missing notes, the incomplete notes. If they only find one physician that's doing it, the incomplete notes coming in later on and amending them and so forth, that's one thing. But if they're finding multiple physicians that are doing that, it's a much broader issue, right? So it would be important then to go and educate the medical staff on what the requirements are for completing the medical notes. Same way, you can also engage like some sort of a mentoring exercise or a counseling exercise if there's like some sort of behavioral issues. You can even ask a physician to start getting second opinion requirements. Like, hey, before you do a procedure like this, come and talk to the head of blah, 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 so you can make sure that you get a second opinion on it, or check with another colleague to sign off on it. Those second opinion requirements is another soft nudge to make sure that the physician is doing the right thing. There's even proctoring, right? So proctoring, it could be turned into a softer sort of a requirement. And last but not least, it could be like a behavioral boundaries courses that people take, because sometimes physicians do have behavioral issues, whether it's anger management or sexual harassment or cursing and all that sort of stuff, right? Just inappropriate behavior. You hear of these situations where a surgeon took an instrument and threw it across the room at another physician, and it literally misses them and hits the wall, or they curse, or they say derogatory remarks about one gender or particular sort of a thing. So these are all things that people need to be educated about. They're just unacceptable at this.
And what we're talking about, keep clear, we're talking about is before a formal peer review action is starting, that these are sort of things that can be done for face-to-face discussions with the physician. And it's very important for the physician who is the subject of this discussion to take these things to heart and to listen, because if you're not listening and you're having this coffee, let's meet over a cup of coffee and talk about something's going on, and you're like, oh no way, no, I'm always right, you could very well end up in the more formal peer review matter that then becomes costly and could significantly affect the ability to work, the ability to get income.
Yeah.
So when these things are happening, pay attention to them. And for example, if it's an anger issue and they're talking about the anger issue and they suggest, well, go to the school, whatever, there's like a cult charm school. There's some places in different parts of the country, you go to a week or so, a couple of weeks, go to those things and pay attention to them, and come out and change behavior, so that you avoid this confrontational peer review that could very well be confrontational, I should say.
Now, sometimes the MECs are reported certain things, and they have to try to get their arms around it. And that's really how investigations begin. So it's usually in regards to a certain activity that has occurred. And the MEC is either informed about it through a routine review process. Maybe they're looking at certain statistics and reports, or maybe they're being informed about it by a specific statement or reporting that's done by an individual. So then what the MEC will do is they will go in and they will start a investigation. And that investigation has to be handled very, very carefully, right? So if the person is being investigated, or a particular person is being investigated, they got to go through the record. When they go and they interview witnesses, those investigators have to be careful about what they say, because you cannot lead the witnesses down the road of a particular answer. Because I think we're all aware of that. If you ask certain questions in a certain way in a certain series, you can lead to the conclusion that you want. So, you know, the investigators have to be, you know, as impartial as possible, as objective as possible, and you know, and then what they're required to do is they're required to report back to the MEC. Now,
What's
again,
important to know, you know, is that you cannot leave. The physician cannot, once an investigation begins, if the physician leaves the medical staff during the investigation, that becomes a reportable event.
that's a problem. Yeah.
Yeah, and let me just one quick note about that. That's why it may be important when there is conduct or something that occurs. It might behoove some folks to pull together the counsel to the hospital, counsel to the physician, counsel to the physician's medical group together before an investigation occurs, to kind of see if something can be worked out beforehand without going through the formality of these processes. Also keep a note that if you're with a hospital coverage agreement, sometimes especially if it's an exclusive agreement, those contracts itself may even allow the hospital to say on this closed staff that is closed to the group, say, I don't want the physician on anymore. And that sort of, I don't want the physician, you know, providing services under this contract. Now, since it's closed, all of a sudden you have an issue where the physician no longer can appeal the due process rights of peer review. So just kind of be very mindful of that.
But that's a double-edged sword, right, Ed?
Yeah.
Yeah. So that it's a double-edged sword. Number one, they got that physician got shorted their rights because under the contract they're being, you know, left, you know, kept out of the hospital. But at the same time, if an adverse decision would have been made had they gone through the whole due process, it would have become reportable to the NPDB. Right. So they avoid that part of it. So it's a double-edged sword. You get shorted your due process, but also you don't get reported to the NPDB if the person actually did do something wrong.
But you also have to weigh the fact you don't want to end up like a Catholic Church where you're moving people along that are problematic, right?
Yeah.
You know, if they're really problematic, you gotta, you know, there's a line of thought of really going through the process. So.
All right. So then, when it comes to the investigation process, you really have to take a look at the investigators. The investigators are all report back to the MEC. The investigation committee can be set up either ahead of time, or they can be done on an ad hoc basis, depending on the situation. You know, the MEC, it would behoove the MEC to make sure that there are no competitors or people with competing interests that are investigating the particular situation. So, like, for example, if you have a cardiologist, you wouldn't want another cardiologist in the same hospital that's got a competing interest to want to get that other cardiologist out to be on the investigation committee. Now, is it illegal? No, it's not illegal, but it defies common sense, right? So if somebody's got an interest in it, keep them out of it. Now, when it comes to the actual hearing panel, then in that sort of a situation, when you have a cardiologist investigating another cardiologist, yeah, no, you just can't have that, because it's too much of a conflict over somebody who's actually going to be making a decision over the person that just got investigated. So keep that in mind. The investigation process has to be done really objectively. And if you do happen to belong to the MEC, do take a look at the directors and officers insurance company coverage, just in case if you are ever named as having done something improper to a particular individual, you do want your D&O coverage to kick in. You may want to ask for a policy of it from your hospital before you do volunteer to be on the MEC. Down here, we have a note, a caution, specialty specific clinical activities may require a same specialty person to serve on the committee. So, you know, sometimes to understand a situation better, you know, so like going back to that cardiology sort of a situation, there may be an occasion for the committee to ask for another cardiologist to be on to serve as an advisor to the committee. They could even bring in an outside consultant to help think through that process, whether something was done properly or improperly. Because if somebody doesn't, if the committee doesn't understand what should have been done properly or appropriately, then, you know, they got to find another resource that's outside instead of just guessing at it. So that's the word of caution down here. Mm-hmm. The process of reviews and investigation results. So like what happens when the investigation results come in? So the investigation committee then presents the fact finding and the analysis to the MEC. They usually make no recommendations unless they're specifically asked to make those recommendations. But the fact finding is really what the investigation committee is about. They're not really there to provide conclusions of situations. So when the investigative committee gets done, then what they do is they take it to the MEC. The MEC then has to review all of those findings and the data and all that sort of stuff. Then they have really three options. One is they look at it and they go, it's nothing. They move along. Like it was just, we looked into it. There was nothing there to be of concern. Let it go. Number two, there could be a small or minor sort of a situation, and maybe it just requires a reprimand. Maybe it just requires like a boundaries course. Maybe it just requires some sort of an awareness of the systems and policies and procedures, and not a big deal. And a letter of reprimand is done, and that's that, and it's done and over with. But the third part, where they either suspend, reduce, or restrict, or wholly revoke the privileges of a physician, well, that's different. If it's that part C here that we're talking about, if it's this part here, suspending, reducing, restricting, or revoking privileges, that requires going through a hearing process. And that hearing process we're going to get into in just a little bit. But if that happens, then that has to go up to the Board of Governors, and they have to actually ratify that. So if it's step 3, meaning like affecting privileges, that's got to go and get approved by the Board of Governors before it can actually take effect.
After the hearing takes place, after they actually revoke or whatever. So they have to have the hearing, and again, they have to meet the bylaw requirements for the hearing to give the physician due process rights and go through that whole hearing. And then when they finally have the hearing, they go, okay, we've heard the physician's side of the story. We've looked at the more evidence, and that they decide to suspend, reduce, restrict, or revoke. That final decision goes up to the Board of Governors of the hospital, the Board of Trustees, to ratify that action. Or theoretically, they can reject it if they're looking at the MEC and they go, oh boy, that MEC it was loaded against the doctor. Theoretically, they may be able to try to do that potentially, but usually, they're going to defer. They're going to defer to the MEC.
Yeah, true. But they could reject it. That's exactly why it goes. So
yeah.
Now let's talk a little bit about suspensions, because suspensions are important to understand. One is most MECs generally have the power to immediately suspend somebody, and they can immediately suspend somebody if there's imminent danger to the health of an individual, right? So, like for example, alcoholism or coming under the influence of drugs, could be cause for immediate suspension. You wouldn't want somebody practicing that doesn't have proper judgment. So that would be an immediate suspension. It can take place like instantaneously. Now, the HCQIA allows for entities to suspend up to 14 days in order to investigate a particular situation. And as long as the suspension is done for 14 days or less, it can be done without a hearing and without notice. They could just pretty much let them know that, hey, look, you're stop, 14 days, time out. And still, it's not deemed a reportable event. However, if you look at the NPDB and their rules, if there's a suspension that's more than 30 days, meaning 31 days or greater, right? 31 days is included in that. So then it has to be reported to the NPDB, which is the National Practitioner Data Bank. So that takes on a whole other level. That's the big ding that we were talking about. Ed, anything else you'd add to that?
No, that's all.
So in order to actually stop a long-term sort of a suspension, the practitioner may seek an injunction to minimize the impact on the income or the blemish on their license and their reputation. So the practitioner can go and seek out a court injunction against them, and that would suspend the suspension, meaning like it would take them off hold. And the disciplinary action should be taken, just keep in mind, all of this disciplinary action should be taken in progressive steps. So going through this case analysis all over again, right? Here's a physician that entered in the notes. They did them too late. It was past the 7-day mark. They were modifying the records. And let's say that they go through the MEC. The MEC process, again, looking down here, there would be an investigation committee. The committee would look into the facts. The MEC would actually send letters and reasons stating the specific reasons as to what action they were looking to take. And then there would be an opportunity for the physician to refute. And then the physician could actually invoke a hearing and request due process. And they would have to be afforded that. Once the physician requests that, then they have to allow for discovery of documents, including interviewing of witnesses and even taking of depositions. So from there, it would go before a hearing panel. A hearing panel would be an actual panel that is usually found by like the professionals, the attorneys involved in the situation. And then the hearing panel would have to come up with a decision, whatever that decision is. If that decision is then either adopted or denied by the MEC, and then they forward it on to the Board of Governors, and that's where the Board of Governors also will usually ratify that decision. Now, mind you, I just want you to understand that this part one, when you're fighting inside the hospital against the hospital, that could have, to an outsider, a physician with privileges, that process could be really simple and it could cost as little as like $25,000 in legal fees, or it could be as high as roughly about $75,000 if it's within the relative norm of what's going on. That's not to say that if you have an anomaly of a case that it would cost even more than that. But I just wanted to actually throw out figures at you so you could understand the financial impact of these fights and what they take.
So it can get costly and it can take time.
Yeah, even though you're right, man, even though the bylaws say, hey, you have to afford a hearing within 30 days, that rarely ever happens. There will usually be continuances given. Everybody is going to get, going to go and do their own investigation, review of documents, and it might be a few months before an actual hearing is had. Right. So it can be problematic. But nonetheless, it's an expensive process. Now, when you step into part two, so let's say that the panel, the hearing panel, comes to an adverse decision. The adverse decision gets ratified. Now, what does a physician do? Well, that's when you enter part two. Once the adverse decision is given, they have to, number one, exhaust all appellate remedies inside the hospital system. Once they've done that, then they can file a lawsuit in court, and that's usually for a breach of contract. Lawsuit meaning like you were supposed to follow the rules, but you didn't follow the rules, So the physician will sue the hospital for that. There could be a declaratory action, which is basically saying, given the set of circumstances, there's no way in heck could that have led to this same outcome. There could be a lawsuit or a count made for denial of due process, meaning that the system did not give the individual due process, meaning like they didn't turn over all the documents, they didn't share all of the witnesses, that they didn't walk them through all of the things that they had the benefit of. And last but not least, there would be a employment or a civil rights claim. That civil rights claim is the only claim that pries open the immunity issue, right? So if there is a civil rights claim put out there, that's what's going to help the physician pry open the immunity that a peer review committee has. Does that make sense, Ed? Did I say that the right way?
Yes, it did.
Yeah.
Yes.
Yeah. Okay. Yeah. So there's it gets very technical, but then once you get into this, you're going to be able to then do discovery all over again, request for all of those documents to be produced all over again, propound interrogatories, which means a whole set and series of questions, and then also depose people and ask questions. So that whole it's like taking a second shot at the same situation. And by the way, do keep in mind that there is no personal liability of the MEC unless there's a violation of civil rights that's alleged. So only then would they have that. Now, oftentimes there will be expert witnesses involved at this stage. Not only will expert witnesses typically get involved in part one of that dispute, but also in part two of this dispute. And during the process, the physician cannot be removed from privileges. So while this whole thing is pending, until there's a final outcome, the physician continues to get to work on. When you litigation is expensive. $30,000 is probably like the minimum side of it that would be spent on it on the physician side. And it could be $100,000 and even greater, depending on how far and how litigious both sides are. So these are now added figures. It's not like you're saying 25 to 75. That's one set of figures. And then it's 30,000 to 100,000 is another set of figures. So say in part one, the cost of it was $50,000, so that's $50,000. And dispute part two might be like, let's say $75,000. So you'd be having a total of $125,000 of legal fees.
Which goes back to my earlier comment, when they go and sit down with the doctor over a cup of coffee and say, hey, we got a problem, here's what's going on. Really have that good conversation and listen, and because you can see how if you go through all these things, it could be very, very costly. And maybe you want to do that. Maybe, maybe you're being set up, the doctor might be being set up by, competitors or something. But just if you kind of weigh that and just think very seriously about that first conversation and see, because you start going down a road that can end up very expensive.
Now, keep in mind, for a hospital, $100,000 probably is not a whole lot of money, but for a physician, it certainly is. Yeah. But for a hospital, their reputation is everything, and their reputation is a lot bigger and wider than the actual physician. So if it's a ding against their reputation, that's where the hospitals will take a real hard hit, even though the money may not be as bad. Their reputation will definitely get impacted. So like what Ed was saying, I think here's another reminder of what all the things that can be done before we go down the wrong road, the road of all those disputes. Remember, you got collegial intervention, you got education, mentoring, counseling, second opinion requirements to get other people, to get other professionals to actually opine on what's going on, proctoring of the physician, sending them to behavior related courses. And then you also have the precautionary suspension of 14 days. And up to this point, nothing has been reported in the national databases. Nothing is out there in the outside world. It's still kept all pretty much hush hush, right? But once you pass that, then it starts to get quirky. And once you go past the 30-day suspension, that's when you've got all these issues of due process, the hearings, going, having hearing panels, getting experts on both sides, and going to court. So the way this process works is, if there is, and in fact, a reason to suspend somebody for more than 30 days, it usually starts off with what's commonly known as notice of reasons. And the notice of reasons is a specifically stated letter that basically outlines what the physician failed to do, or the requirements that they fail to meet. So that's called a notice of reasons. And in that notice of reasons, it'll say that you have the right to a hearing. So then what the physician will get to do is, here in part 2, is that they will get to trigger that hearing. So that hearing is typically required to be given within 30 days, but very rare are both sides ready within 30 days to go have a hearing. So it will usually get extended by a few months. And that's when step 3 comes in. There will be pre-discovery done inside the hospital system. And that's when the lawyers from both sides will go and find a hearing officer, and there will be a panel selected to preside over the issues. So it's fairly technical, fairly complex, fairly expensive. Now, do keep in mind, the hospitals go through this process regularly. The individuals do not. So it's really important to get attorneys that have gone through this process on either side, one side or the other. These are rare things that occur, but they do occur often enough that you've got to know what you're doing. Let's say that the hearing panel then came to an adverse decision. Here we lay out again the things that could be done, which is you could do a notice of appeal, or you could be filing a lawsuit. And once that happens, you have to file the lawsuit within 30 days of the adverse decision. If you don't do it within 30 days, you may very well lose the right to proceed forward. The discovery in court will start all over again. And actually, I think it's even better to do discovery when you're in court, because your handcuffs come off, and the other side doesn't have as much opportunity to cloak some of these things. Now, mediation will be required before you can go to trial, or even a motion for summary judgment. But there will be a mediation where the physician and the hospital will have to come together inside a mediation room and discuss what the options are and how they want to resolve it. And then ultimately, it'll lead to either a settlement, a summary judgment, or a trial. Now, looking back at the situation that we had started, this is a very long road. Part 1 will take anywhere from 3 months to 8-9 months. Part 2 will take anywhere from once those, let's say, 6 months are over in the first part, then it has a life of its own. It could take a year, it could take 2 years or 3 years. I've actually seen people be in this part 2 for 4 years at a time. So it can be a really long process. It's a costly process. Now, when we talk about these fees that are down here, remember, it's not all fees that are due on day one. They're accrued as the whole case progresses. So let's say that something lasts for 10 months. You may very well be in it for $7,000 a month of fees for 10 months. It'll be something like that. So that's what the legal costs of it are. And with that said, anything else you would touch on, Ed, before we close up?
So you covered it really well.
Okay, thanks. If you have any questions regarding medical staffing and privileges, if you'd like a copy of this presentation, please do let us know, and we're happy to help you.
Thank you.
And the other thing is, if you do have any questions while you're watching this on a recording, take note of the phone numbers and feel free to give Ben or one of the other attorneys a call to discuss your problem. Anyway, with that, we're going to bid you a goodbye. Anyone have any last words?
Well, thank you, Charles, for putting this together, by the way. And I appreciate
always
this
a
opportunity.
pleasure to deal with the Mirza Health Law Group.
Thank you.
And we'll see you in
Next month.
in 30 days. Thank you. Bye-bye.
Very good.
Thank you.
Thank you, guys.